So we'll look at the court's handling of political parties and internal democracy of this political parties. So, of course, we've seen that the issue concerning the internal democracy of especially the major political parties continue to be at the front burner of litigation, even long after election process has been concluded. So what do you have to say, concerning, the issues surrounding this particular topic?
Yeah, the Electoral Act and the Constitution, has made provisions that there must be internal democracy in the respective parties. And that is to say that each political party that wants to conduct primaries or other activities must ensure internal democracy in the process. And the attitude of our courts over the years is that internal affairs of the political parties should be left to the political parties to decide, so long as they follow the process. And in many of the cases decided by the Court of Appeal and Supreme Court, the position has been that since it has to do with political parties' internal affairs, they should be allowed to continue to handle those things. But then it has come to be observed that sometimes the internal democracy of the political parties are not actually done properly. That due process have not been followed. Well, there are cases where there have been oppression, victimization, and so on. A case in point is the case of Amaechi and INEC. That was a case where Amaechi was a candidate of the DP for the primaries. He won the election, the primaries, and his name was submitted to INEC for purposes of that election. And some days before the election, his name was removed. The party wrote to INEC, substituted his name with that of mayor, and by looking at it based on what had been going on before then, the court would have said, well, it is an internal affair, let the party go ahead and they do whatever they wanted to do. Election was conducted, and of course we know that in Nigeria is a political party that wins the election. PDP won in that election, and Mayor was sworn in as governor. But Amaechi did not accept it. He went to court, and the tribunal and the Court of Appeal did not give him justice. They said, well, it is an internal affair, internal affair of the political party, PDP. But by the time it got to the Supreme Court had a different view. The Supreme reasoned that it is the political parties that contest elections, and that is why in Nigeria as of today, no individual can contest except on the platform of a political party. And that since Amaechi was part of those that conducted the primaries and had overwhelming victory, his name was submitted to INEC for purposes of the election, that the subsequent substitution of his name was irregular, was wrong, was unconstitutional. And the Supreme Court said that as far as the law is concerned, in the eye of the law, Amaechi was the one who contested election. And that since PDP won, that the person who had won as far as the law is concerned is Amaechi. And the Supreme Court went ahead to order that Amaechi be sworn in. And that was how he got sworn in. Now, assuming the Supreme Court had told the line of internal democracy and the party having sovereign powers over its internal affairs, Amaechi would have gone home empty. And the Supreme Court had cause to refer to some cases, in the case in England, Parker and Parker, where Lord Dennis said that once a party had come to court and the court had decided in his favor, he cannot go home with empty victory. He must go home with real victory. And real victory in the instant case had to do with him getting what he deserved to get. And of course, the Supreme Court lambasted the party for even going ahead to get Omeya sworn in during the pendency of the matter. So you discover that in Nigeria today, political parties sometimes oppress their members, and for there to be fairness, for there to be substantial justice, the eye of the law must at what goes inside those political party activities to ensure that individuals who are members of the political parties are not subjected to intolerable oppression, intimidation, and all that.
All right. Of course, we would also need to ask some questions concerning this your line of thought, that who might have to get Barrister Deji's opinion on this topic, because from what you've said, it seems to me that a political party can even win an election without fielding a candidate at all.
No, that's not what I've said.
But
there must be a candidate. But in the context of what we have today, if an election is won, it is the party that wins the election, but they must present a candidate. And that was why when we looked at what the drama going on in Rivers State, the drama going on in Rivers State, it is if a candidate on the platform of a party has been elected as a member of a state of assembly, and the person decides to decamp to another party, he leaves that position of the House of Assembly because it is the party that won the election.
Yeah, of course.
That is the law.
What I'm saying is that
is the law.
If of course there's an issue, a little bit of issue within that Supreme Court, of course some legal jurists would want to analyze, because some would have argued that that particular case is cited. PDP should have, their vote should have been nullified, and the next party who came second should have been declared, because it's saying because they didn't have a candidate. If Omeya, who was presented, is not qualified to be a candidate in that election, of course, but let's get Barrister Deji's opinion.
No, well, let him come and then I'll still give you more insight into what the Supreme Court reads. And the Supreme Court decision has been acclaimed. There is a locus clause, a landmark decision that went and meted out justice, substantial justice, not technical justice.
Yes, thank you. I think I'm more interested in how the judiciary has assisted in evolving internal democratic process of our parties. And if I'm to score the judiciary in Nigeria today, I will score them below 30%.
That's below average.
Completely.
That is a failure.
Yes, obviously. That's exactly what I'm saying. Because why I say this is that the judiciary is supposed to assist the political parties to infuse a democratic process in the operation of the parties, in the process of selection of candidates or who emerge as representatives of that party for the purpose of election. But what we have had over the years is this jurisprudence that they cannot look into the internal processes or the internal democracy or matters that relate to the internal affairs of the political parties. And that has wrought substantial injustice to our electoral process, to our political process, and to the advancement of jurisprudence on election in this country. That's why we have a lot of impunity today in the process of elections. You find a situation where somebody who did not even participate, all right, in the primaries of a political party is presented as the candidate of the party over and above those who participated in the electoral process. And we have had our courts justify such nomination.
Can you give us an instance?
Yes, the example of Lawal Gwadabe and Ahmed Lawal is an example. The Ahmed Lawal case is an example of a situation where somebody did not participate in the primaries
Is it not similar to the Senate president also?
Oh, of course. Of course.
That's Akpabio. It's similar.
Of course. In a way. Now, the issue is this. Now, where somebody who did not participate in the primary is picked by the party as a candidate of the party, and all others who have participated, and out of democratic process, somebody had won that nomination, and that person is not. It doesn't allow well for a good governance at the end of the day. And our court will always tell you we cannot look into the internal affairs of the party. The party has the liberty and the discretion to present a candidate for an election. And I think we should get to a point where the issues of fair hearing, due process, and good governance should be looked at, and proper representation. For instance, somebody is made to pay for applying maybe for forms of a political party to contest an election, and after he has paid a political party, he has submitted his form, he has undergone the primaries, and then a winner at the match. That winner is prevented by the caucus of the party, or by the national working committee of the party, or by the leadership of the party representing that party in the election. I don't think the Supreme Court will be justified, or any court at all will be justified to say we cannot look at the matter. It's an internal democracy or internal affairs.
Yeah, but it seems to me that from what you are saying, it seems to be totally different from what Barry Sylvia have said. He said that
yes,
the Supreme Court. He said that the Supreme Court are always interested in looking at the internal democratic process. Yeah, but and he cited the issue of Amaechi.
Let me clarify. Let me make everything clear.
Yes.
What my colleague has said is in tandem with what I said before. What I said is that the issue of internal democracy of political parties should be the concern of the courts. The court should not allow political parties
to do
whatever they like, oppress their members internally, and the courts will wash up their hands like Pilate and so.
Yeah, but you said that in Omehia and Amaechi they did that.
Let me say clearly what I've said before. In Amaechi and INEC,
yes.
Amaechi participated in the primaries. Omehia did not participate, and Amaechi's name was submitted to INEC.
By the party.
By the party.
This is an internal affair of the party.
Now, yes.
And the court came
now,
and looked at
hold on. After the name has been submitted, subsequently his name was withdrawn, and somebody who did not even participate was submitted. And the election was conducted, and the mayor won because PDP won the election. And then Amaechi went to court, and the lower court said, no, it's an internal affair, we don't have business with that. The Supreme Court said no. That in so far as there was a candidate who participated and whose name was submitted, that is the party that has won, as far as law is concerned, that in the eye of the law, it was Amaechi who stood in and conducted the election, and that the Amaechi should be sworn in, and that was done contrary to the doctrine of internal democracy and course having nothing to do with it. Yes, abdication of judicial responsibility. The Supreme Court said no. Now, of course, after that, there have been instances where people who did not participate in primaries or parties were submitted and they still came out as winners. What I am saying, which leather friend is an agreement, is that court to scrutinize the primaries of these political parties, their internal affairs, to ensure that there is compliance with the law.
Just like they did in Amaechi and Omehia.
Exactly.
That means if the Supreme Court is interested in all of that,
so
what we should be looking at is, why do they cherry pick in the ones they look at and the ones, or is there any reason why they didn't look at these subsequent ones that came out, especially the one you mentioned about the Senate president? If they were able to look at the Amaechi, was there any reason why you didn't look at this other one?
We don't seem to have a consistent jurisprudence emerging from our electoral cases, and that's a big problem. There's no certainty to the principles of law that our courts are holding on to. Now, there have been a lot of plethora of cases after that case that my friend cited where the Supreme Court have said we will not look into the internal affairs of the political parties. And one does not even know the origin of this principle. Where is it a constitutional principle? Is it a statutory principle? Or just a figment of principle that was developed by the judiciary? We need to examine the jurisprudence behind this idea of abdication of judicial responsibility. Is there any place in our law where the judicial powers are being removed in looking at the internal democratic processes of parties? I think we need to examine that, because I'm not aware of any law that says that the courts cannot look into the internal democracy of parties. Section 6 of the Constitution gives judicial powers, expansive and extensive judicial powers, to the courts,
Yes.
to determine the rights of persons, to
Yes.
look at any political parties and their operations. So I don't see why the Supreme Court, how they have come up with that concept.
Okay, but Mr. Deji, just
And the basis of the legal
just a minute, because we've had issues. Of course, when we talk about the judiciary, we should also expand it to include the lawyers who litigate these cases in the court, because they are also the ministers in the temple of justice, and they work together to ensure that justice is done. Right. Okay, so we've had instances, as we are talking about the judiciary, should we also look at the lawyers who litigate these issues? We've had instances where the courts, that is the judges now, have had issues where the lawyers who handle these cases do not couch their prayers properly or do not follow the law. For instance, the issue of internal democracy, it has been consistently said that if you do not participate in the process of the primaries, you can't bring this matter to court. You have to be a participant in the process for you to have the local standard of bringing the matter and for the court to hear you. In the internal, for instance, in the issue of Lawan, the person who did not contest the primaries can definitely not bring this issue. So if another person,
the issue
has
the complexity to what you have just said. Let me just make this point, my dear brother. Before you go, there's a complexity to what you have just said now, which you have not considered. Now, the person who can complain about internal democracy not being followed is the person that had been sidelined
or denied
his rights.
Yes.
Okay, the person that the party nominated who had not fulfilled the conditions, okay, of being a candidate will never go to court to say I was not presented because he didn't participate in the primaries. And so what you find is that it is true that somebody who had not participated in the primaries does not have local standard. But the point I'm making is that there should be no reason under the law that will make a court not to have the power to look into what the parties are doing. It may not be even for the purpose of election, even the appointment of their officers. You know, political parties are creation of law. And as creation of law and statute, they are bound to be investigated.
Yeah, but we need to also be fair to the judiciary in our discussion here, because they have never said that they lack the power to look. We saw what happened with the Labour Party issue with the Lamidia Papa faction and the other faction. Now the court has always robustly looked at this issue.
What is the basis for
now,
decisions?
the point that is in issue is this. Clearly, the Constitution has said that any person whose rights and obligations have been tampered with, violated, that such a person has access to the courts for determination of his rights and obligations. Now, under military regimes, we've had cases of outer of court jurisdiction that the court should not look at certain things, should not even entertain applications or suits. And then we thank God that the issue of outside jurisdiction is no longer there. But in the area of election petitions, electoral matters, that ouster is still like a monster that is there, and it's time to destroy and kill that monster once and for all. There must not be any ouster of the jurisdiction of the court. As far as political matters are concerned, like my brother said, political parties are creations of the law, and the law mandates to have constitutions, and they are bound to follow the letters of the constitution.
Yes.
And of course, you have seen a recent passage in Nigeria where political parties will be fielding different candidates, different lists of candidates who have factions. If they follow their constitution, that cannot be. And because over the years, the courts in some instances have said no, let them do whatever they want to do. It's a political party affair. No. Intra-party disputes affairs must be taken to the courts for the court to decide whether the party have actually followed the clear provisions of the constitution of the party, the electoral act, and the constitution. These are the things, because we have seen instances of injustice being meted out by political parties to their members, and that should not be. The issue of internal democracy of political parties should not be left to the party. The court must have cause to look at what is going on inside the political party, just like the Supreme Court did in Amaechi's case. Of course, we know there are other cases where the courts have said no, these are, but that is against the clear provisions of the constitution, because somebody who has participated in an election, in primaries of a party, and has come out victorious, and later the party remove his name and put someone who either failed in the primaries or did not even participate in it. Is that justice? Is that compliance with the constitution and the laws of the country? The answer is no. I believe that it is high time that all the courts that have to do with handling of election political matters to look into these pre-election matters of these political parties and ensure that candidates who have won or participated are not denied their rights, and they are muzzled up their silence because it's an internal affair. That is not justice, and that is not done in all crimes in other jurisdictions. Why would that be allowed to continue? And that is why you discover that political parties sometimes put stooges, those that will do whatever they want, and that would deny the masses
All right.
the dividends of democracy.
All right. Thank you very much.